to the investment Sukuk. Okay, so AUFI has defined different investment Sukuk in different way, and I think I've been told that you've been imparted that session previously. So what are the asset base? You see under the asset base Sukuk structure, if the seller has, the originator has an asset and he wish to generate cash flows, he is short of liquidity, the client sells asset to the financer at purchase price on cash basis, right? The financer makes the payment, cash proceeds equivalent to the purchase price what is agreed for the asset, and then again it's a basically sale and lease back structure. You need liquidity, you have an asset, you sell the asset and lease back, the financer again lease back you the asset. You see at number 3, the financer lease the asset back to the client, and asset is used by the client, but the ownership is with the financer. And for that matter, ijara Sukuk are issued to the financer. So these ijara Sukuk has the obligation, the rental obligation on the part of the original to be paid to the financer over the period of time for use of the asset. So at the end of the lease period, what it happens, because if we make it part of the contract, that at the end of the period, the lessee will again, the client will again purchase the asset. So this, this is not allowed in some jurisdiction, and most of the Sharia scholars do not allow sale and buyback transaction. But sale and leaseback transaction is allowed, where the ownership is truly transferred to the financer. So at the end of the lease period, client gives the option to purchase the leased asset if financer agrees, which is normally, but it's not made part of the agreement, but it's a part of understanding between the client and the financer. So under this arrangement, at the end of the period, the financer sells back asset to the customer or the client. So this is basically, you see, there is no SPV. It is directly based on the Sukuk asset. So financer has a claim on the asset. If client defaults, the financer can sell the asset in the market and to recover his proceeds. So this is asset-based structure, and the other structure. And you see here he has a direct claim on the asset, exclusive claim on the asset. Here you see what asset-backed Sukuk, how they work basically. Okay, in this way, I mean, you need to overview, you need to see what the purpose of the transaction is. If it is to generate some liquidity, the asset is given by the client, and if it is the purpose is to actually acquire the asset, it may involve a third party in this transaction. So in the asset-backed Sukuk, the client sells asset to the SPA, special purpose vehicle. So sale and purchase agreement between the SPA and the client, a true sale is, try to make a true sale in the Islamic terms, and the originator sell his asset to the SPV. SPV becomes the owner. SPV is normally owned by a trustee. Trustee should not be the beneficial, should not have any beneficial interest in the SPV or with the client. So these terms and these requirements are covered through the regulation. What is the need of, what is the requirement for the trustee, and what is the requirement for the SPV, who can act as a trustee, and the SPV again. SPV issues Sukuk to the investor. SPV finds investor and issues Sukuk to the investor. Financer gives money and subscribes for the Sukuk, and that money is returned or paid to the client. So investors subscribe for the Sukuk. SPV uses the subscription proceeds to pay the originator for the asset purchase price and simultaneously issue the Sukuk to the investor. and the process goes for certain terms, for certain time period, or till the life of the asset. At the end of the period, the asset is again offered to the client. Here, the basic purpose was the asset backs, and the financer do not have direct claim on the Sukuk. In case the client defaults, the ownership and the rights goes to the SPV. In generally, what we see, generally the asset, the claim is not against SPV, because the trustee is acts on as a trustee, and the claim normally is settled by the clients. But there are certain legal issues, so which we need to address in the regulations as well. So these are the the modes where the asset or the Sukuk can be structured. This is a general common in Ijara Sukuk. I skip it here for the sake of brevity, and to proceed further and to touch our real topic, that is the regulation. What are the common features of the Sukuk? You see the Sukuk holders has a right to receive a proportionate share of the profit or Sukuk rental flow, so coming from the underlying assets. So typically the ownership rights relate to the beneficial interest. So this is very important, the beneficial interest, because many of the jurisdiction, or many of the law which we or the laws or the regulation, it do not recognize the word beneficial interest. They basically go for the real interest, the real sale, I mean, which is documented and where documentary evidence is available. So beneficial interest through the contract or through this Sukuk agreement, the law or the English law, the Western law, or the laws of the subcontinent, they do not recognize. So this is very important area for the legislation. So in the underlying asset, basically the underlying the beneficial interest in the underlying assets does not necessitate a true sale in this case, right? So Sharia compliance, again, it can be achieved by transferring the what we say, the true sale, that is not necessitated, but the requirement of the Sharia are met. So it's not a legal transfer, but it's Sharia requirements are met for the transfer of the assets. So consequently, Sukuk have not necessarily entailed any asset transfer in the form of off-balance sheet, right? So in the event of default by the obligor or on maturity, the only recourse available to the Sukuk holder is to put the asset back to the obligor, which creates a payment obligation in favor of the Sukuk holder. So you see, in this respect, the Sukuk holders' claim on the obligors, they are equivalent to their investments. And for that purpose, in the period of default, they are known and they are considered to be the unsecured creditor of the transactions. So these are the common feature of this. So interest-bearing security is obviously not allowed in the Sukuk, but we can use the conventional benchmark of any country. I mean, if we can use LIBOR, like in Pakistan, we use KIBOR, and maybe you might be having your own benchmark to use in pricing mechanism. So again, now what other areas we need to know before framing the legal framework for the Sukuk is the classification of the Sukuk. So classification in terms of the tradability and non-tradability. So every Sukuk is not tradable, because the objective is what? Objective is to grow the capital market, to develop a capital market, and every instrument which is tradable is more attractive to the for the capital market. So in terms of tradability, the Sukuk can be classified tradable and non-tradable. Both the features are dependent on the underlying tangible assets or proportionate ownership of a business or investment portfolio. So EOFI standards 17, which is on investment Sukuk, it tells us that Sukuk to be tradable must be owned by the Sukuk holders with all rights and obligation of the ownership in the asset. but normally it doesn't prevail in the Sukuk market. So thus the manager issuing Sukuk must certify the transfer of ownership of such assets in the Sukuk books and must not keep them as his own asset. Again, Sharia Standard 21, which is on the financial papers, it tells us that Sukuk to be traded must not represent receivables or debt, except in the case of trading or financial entity selling all its assets with certain other conditions. So as per the OFI, Sukuk based on Ijara, Istisna, Mudaraba, or Musharka principles are tradable. Because here you see in Ijara, you are owner of the asset, so you can trade the asset. If you are not owner of the asset, you can't trade it. In Istisna, you are also again, you owner of the product. In Mudaraba, so you have a share, you are a partner, you are owner of the business or the project. Or again in the Musharaka principles, you are again, you became owner, and you can sell your share to anybody. So that is tradable. So for Sukuk tradability, some scholars require the tangible assets of the organization or the entity should at least be 50% the total pool, if you wish to make it tradable. So where the Sukuk investment lies, the tradable assets in that pool must be around or at least at 50%. So the non-tradable not represent ownership of the tangible assets. They represent receivables or cash or goods. For example, Sukuk of Salam, Muraba are not tradable because what they create basically, Muraba, when you sold the goods, it creates a debt. So that can't be traded. Again, Salam, you paid in advance, it created a debt. So that cannot be traded. The real commodities can be traded. So these are important, areas which we need to understand before going into the details of the challenges of the regulatory framework. Now, coming to our topic, which is, I was told to discuss primarily. So the challenges of the regulatory frameworks, there are lots of challenges, there might be legal challenge, there might be Sharia compliance challenges. The first of all, what we face is the legal infrastructure. Legal infrastructure is it's in a varied cross countries operating in the Islamic finance. They don't have a legal infrastructure for the Islamic products. So the status of the development of the major determinants or the success of the Sukuk relies on having a firm legal infrastructure. So from the perspective of a new Islamic finance jurisdiction, the legal basis for Sukuk development is not sufficient, because the legal basis for Islamic financial development as a whole still relies on the conventional banking laws and regulations. So with this regard to Sukuk development, first challenge the new entered phase is the non-existence of Sharia compliant asset securitization law, number one. So normally what is followed in the subcontinent is the Western law, so which is not in line with the Sharia dictates. And the asset securitization law clearly states that securitization cannot be structured through debt. So the concept of forced charity and recovery of loss due to promise of the client, so which is a basic requirement in many Islamic contracts, are not recognized by the courts. So they have to be brought in line with the Sharia principles. So again, the enforceability of the Sukuk contracts. So dispute between the Western law and the Sharia law. Before assessing issues surrounding the enforceability of the Sukuk, it is imperative to portray the kind of conflict happening in the sphere of the Islamic finance due to the dual legal systems that governs the jurisdictions. So English common law and civil law each present distinctive problem when they collide with the Sharia. So problem in using Sharia finance under common law jurisdiction is the conflict that emerges between the Sharia law and the common law. The national law or the common law, what we practice is always prevails over the Sharia law. When we go to the courts, courts always upheld the national law. They don't bother for the Sharia law. So courts do not recognize the beneficial ownership, as we just I told you while discussing this Sukuk structure. Courts do not recognize the beneficial ownership of the leasehold interest. So in the absence of the legal transfer, the Sukuk holder is at loss. So this we need to cover, this challenge we need to address in the regulatory framework for the Islamic finance. So legal issue can also be seen in the case of we have a case, Shamil Islamic Bank of Bahrain versus a pharmaceutical company. So in that case, the defendant was not been able to make payment for his financing to the bank because the defendant argued that the contract was so worded with the Sharia principles and not to clash with the English law. So, however, the judge ruled out that there cannot be two separate laws. Okay? So they said there can't be two separate legal systems governing a contract. So that the national system is valid law to govern the contract, and they rejected the Sharia principles in the Sukuk. So in many of the Sukuk issues, there is again another issue is the cross-border transactions. So there is a problem with the law to be enforced. So this enforceability issue causes legal impediment due to the inability to obtain satisfactory legal opinions, which emanates from the sale of the assets between the originator and the investor through the SPV. And it's also due to the various bankruptcy law matters. Here, there is a confusion about which law can be enforced and to what extent that law can be enforced in Sukuk issuance. Again, another issue is the true sale execution. Executing a true sale is a crucial element in Sukuk operation, as it constitutes a real transfer of ownership from the originator to the Sukuk holder via the SPV. So, nevertheless, some Sukuk issuers do not execute true sales. So, frankly, in large Sukuks, we do not see the real or the true sale. As with the asset-backed Sukuk issuance, normally it is not true. So due to the absence of the relevant law to deal property in bankruptcy in such cases, we are always at disadvantage. So this is also another in a case study. So Nakhil Sukuk case, wherein the leasehold interest were not viewed as a right, as a real right or the property rights. So under the relevant law in the UAE, which is applicable in the Emirates, instead the rights were viewed as unregistered personal contractual rights, which binding the properties as opposed to the rights of the law of the land in questions. So here again, it was a disadvantage to the Islamic financial institution in against the Islamic financial institution. Similarly, in some jurisdictions, the concept of beneficiary right or beneficial ownership has not been recognized for sovereign Sukuk, as the state assets needed for government operational activities cannot be transferred to the third parties and must be subject to the approval of the government body. So this indicates that the civil law indeed impedes the undertaking of a true sale that would be enforceable in Sukuk issuance. And the next thing is the bankruptcy. So bankruptcy law is crucial for facilitating a true sale transaction in which the investors are protected and will receive payments on asset-backed securities even in cases of the originator's bankruptcy. So for in some countries, under civil law regime, there has not yet emerged a proper bankruptcy law to protect Sukuk holders from the bankruptcy. So thus, in case of bankruptcy, the court follows the legal proceedings that the financing is a transfer of collateral because the presence of recourse to the originator. Hence, the enforceability of the law in the court will exactly the same between Sukuk and the secured collateralized loan. So if you have a secured collateralized loan and if you don't have a secured collateralized Islamic security, so you cannot claim your right, because what we do, we do in the papers again. So SPV is bankruptcy way. SPV has also an important element for the Sukuk regulation. An SPV is a bankruptcy remote firm, which is independent from the obligor. The SPV is established based on the trust law. It is basically, established on the trust law, in which the Sukuk originator and the transferor transfer the asset to the Sukuk holders as a beneficiary. And SPV acts as a trustee with the good faith. So therefore, trust law plays an important role in governing the SPV establishment. This trust law recognizes the equity for remedies in which beneficiaries are provided with the equitable treatment remedies against the faithful acts. So within the common law treatment, the legal rights of the trustees are bounded by the legal rights of the beneficiary. Whereas in contrast, under the civil law treatment, the beneficiary have no rights or control towards the asset managed by the trustee. Beneficiary have no right. So if you have beneficial interest, you have no right on the asset of the trust. The court will not award or will not give you anything in case of default. So in such cases, in the event of default, the Sukuk holders do not have recourse to the asset due to civil law restrictions. This is another problem. So in cases where the SPV is located outside the originator country, again, if you control the SPV law, if you make a sufficient SPV law for your country, so what will happen if you do it? If you issue cross-border Sukuk. So in cases where the SPV is located outside the originator's country, due to absence of the specific legislation on certain issue, the Sukuk holders get nothing. This can be seen in the, Tamwil Sukuk issuance. It's another case study for you to understand the legal complications, in which the SPV was located in the Cayman Island. So far from Dubai, the originator countries. And in case of default, they could not get anything out of it. So this is another issue to address in the regulatory areas and regulatory frameworks. The next important area is the regulatory and financial implications of Sukuk. The financial implications. In the financial implication, the role of rating agency is very important. So it is an inevitable fact that when investor purchase Sukuk, they are interested in the risk related to the issuer instead of the underlying asset of the project. So undertaken due to prevalence of the asset-backed Sukuk, this is happening because the methodology used by the rating agency for Sukuk rating is similar to the conventional bond rating. Since no independent Sukuk rating has yet been formed for the Islamic, for Sukuk rating, in this regard, since the very essence of the Sukuk is the project financing backed by the real assets. So rating agency holds shift. So they should shift. I mean, if it is backed by the real asset, so they should shift the paradigm of the Sukuk rating. Whether the risk proxy is based on the feasibility and prudential evaluation of the assets, or the theoretical risk, or it should be based on the actual condition of the asset, actual evaluation of the asset. So it is important also for rating agency to give assurance to investor through information, notification regarding the underlying assets quality, so that they can make informed decision. So next point is the standardization of the Sukuk, which we need to address. Since there are large uncertainty and conflicts arising from the Sukuk transaction, as well as the Sharia divergences, Sukuk need to be standardized and streamlined in terms of the legal documentation and Sharia standards. So EOFI Sharia standards for the Sukuk have been set properly, but the problem is that the standards are not binding among key players in the Islamic financial industry. So they are voluntary. If you adopt it, so you are allowed. But if you don't wish to adopt it, so you go for your own with your own standards. Like the Malaysia has done, they have changed many EOFI standards and tailored their own standards according to their market needs. So you can also do that, but it will again hit the standardization, the global standardization requirement. So therefore, the enforcement of the standards is critical at the moment for having Sharia compliant Sukuk in the market. So beside these, there should be uniformity of law for offshore jurisdictions, as well as the methods to resolve the conflict of legal system that applies to all Sukuk issuance across all jurisdictions. The goal would be that in a case of default, the case could be resolved pursuant to a standardized legal documentation. So we need to have a standardized, documentation and standardization of Sukuk issuance for all the jurisdictions. And the last, again, the next area is the again, coming in the financial implication is the Sukuk feasibility analysis. As I've discussed, based on the conventional standards, since one must undertake a true sale undertaking, as well as full ownership of the asset, use of fruct of the project in Sukuk transaction, it is important that Sukuk are structured in a manner backed by an identified portfolio. And that portfolio should be of a high quality of assets, which is in line with the asset securitization and prospective projects. Hence, the value of the identified portfolio of assets and project must represent the market value of the Sukuk issuance in order to ensure that there are genuine interest over the portfolio of the asset or the project. So in this regard, it is vital for the Sukuk lead arrangers to exercise careful due diligence over the identified assets through scenario analysis. So both best and worst scenario, including the stress testing analysis. So where the asset performance in different financial situation over the Sukuk tenure is evaluated. So in addition, an on-site visit is required to look over the identified portfolio of the asset and whether or not the assets are in existence and productive enough to generate positive cash flows. So with regards to project identification, there must be proper feasibility analysis over the investment projects plans, and the regulation must address this area as well for the financial implication. Okay, Sharia compliant Financial innovation of Sukuk is another area. So possible Sharia compliant financial innovation can be suggested in order to give the financial protection to the Sukuk holders from the legal uncertainties. So I wish to conclude here the area of the regulatory framework, the challenges of the Sukuk regulatory framework. So what I've discussed here, the current Sukuk practices and the legal compatibility issues of the Sukuk in the wake of the Sukuk defaults occurring in the Islamic financing space, regulatory treatments and practical Sharia compliant financing innovations are required to mitigate future Sukuk defaults and to to cover up the regulatory lapses. So instead, there is a significant legal unpredictability governing Sukuk transactions. With the current structure, what we of the Sukuk in the jurisdiction where there is no legal framework is available, the problem still revolves in the Islamic capital market. So separate, comprehensive, and dedicated law for the Islamic finance and Islamic securities, addressing all the issues which we've discussed and which prevail in the Western law, including the true sale, securitization, the cross-border offering, their laws, bankruptcy and dispute settlement, issues of the taxes, issues of the double taxation somewhere, or other issues which I have left for the sake of brevity. So that need to be addressed in the legislation. So the bottom line, without addressing the issues discussed in the Sukuk structure, is insufficient to protect the legal rights of the Sukuk holders to the securitized assets. So for the way forward, closer engagement between the key player, regulators, Sharia advisors, and the scholars in the industry are needed to discuss and improve the feasibility of these regulatory and financial implications. So therefore, again, I again suggest a robust regulatory framework for issuance of Sukuk. So it is must before developing a Sukuk market in the country. So while drafting and introducing a regulatory framework for issuance of Sukuk, which area needs to be covered at least, I'll discuss in the next slide. And that is, I guess, we're left with a few minutes. So that will be the last slide, which I discuss with you. So these are the last few slides in which I would like to share what areas need to be covered in the regulatory framework for issuance of Sukuk. So framework must discuss number one. It may be in the form of the regulation. It may be in the form of rules. It may be in the form of guidelines, or it may be in the form of practice notes. So the issuance of Sukuk is governed by the various legislation, and the regulatory framework for Sukuk may consist of different set of documents, including the enabling law as well as the rules, may be regulations, so guidelines, practicing notes issued by the security regulators in particularly. So, but if you don't have a security regulator for that matter, I mean, any other authorized authority should do it before entering into the Sukuk market. So these frameworks, I mean, and within these frameworks, what you need to cover? You need to cover the role of the investors, number one. And again, you need to discuss the role of the obligor, the issuer, lead manager, investment bank, maybe any other, maybe conventional bank, maybe Islamic bank, maybe investment bank. You may authorize any other entity. So regulators, relevant authorities, who to regulate this area, and what are their powers, and they must be given proper powers to regulate and enforce the laws. So Sharia board is an important part of the regulations. The role of the Sharia board, Sharia consultant, Sharia advisors, in any form, the involvement of the Sharia scholars is very important in this process for the credibility of the product. So we need to define again in the regulation. So what should be the requirement and fit and proper criteria for the Sharia boards, or what is the fit and proper criteria for the Sharia advisor? How can we remove it? So for what period, I mean, they can be appointed, and in case of dispute, how these disputes can be settled? What will be the role of the regulator? And if the regulator has its own, Sharia board, then the authority must be given to that board to resolve the national level issues. So that needs to be, put in place for working or for entering into this Islamic market. So legal counsel, their role, services providers if required, so their role, auditors' roles, again, investment agent if you appoint for the Sukuk and for its promotion, its selling, whatever the purpose, you just give their domain, their rights and duties and obligation defined, so that any future dispute should be legally covered, should be legally settled, and that they must have a guidelines. So, and if you wish to add underwriters in the schools, so in which form you wish to place it, for public offer or for private placements? Scoop, if you offer the scoop for to the public or for private placements, you need to have an underwriter. If the size of the scoop is huge, so how many underwriter you need to get in, and what should be the qualification of the underwriters? So again, the law may contain again the inability, the legal provisions for issuance of the Islamic securities. Normally, what we see in many jurisdictions, they seek the inability clause uh, from the conventional securities issue. So capital issue, conventional paper issue, conventional instrument issue, they drive the power, the enabling power from that. You must give a separate power for the Islamic securities. The law should require the application process, approval process, the application for approval of the securities regulator in respect of the issue of scoop to be made as per prescribed rules and guidance. So format of the application, information, what you desire, what you require, documents, what you need to have with the application. So all these areas are covered under the application process. Again, the other area which need to be covered in the legislation is the legal framework regarding the eligibility clause. Who is eligible to apply? Who can be the issuer? So you need to decide the issuer based on the need of the requirement in your country. So this issuer may be a corporation, a body corporate, formed or incorporated, or it may be a new body, it may be a new corporation or an existing company. So within your country or outside or it may be a foreign company. So you wish to add them or not, you want to allow them or not. So you may have onshore or offshore Islamic capital markets. So you need to have a proper law to regulate and provide for the matters relating to the activities of the markets and the intermediary risk in the capital markets. So hence the provision of law must consider that the issuer of the scoop be a national company or an international company. So you need to cover in the eligibility clause. Again, the rating, if you wish to add, what should be the rating of the instrument, what should be the credit rating of the company, so who can issue it. So you set basic requirement for the issuers. Again, you can in the law you can also set the condition for issue of scoop. It may include the investment grade rating requirement. So security clause, the issuer to arrange appropriate security where required in the form of acceptable, which is acceptable and eligible in investments for them. So the consent of the depository company, again, if you have a depository system, so depository consent of the depository system, how to obtain and before issuance, to declare the Sukuk as an eligible security for depository system. So your requirement for the listed Sukuk may be quite stringent for as compared to the requirement for the privately placed Sukuk. So both have different frameworks and different requirements. So different conditions, with the different conditions you can allow them. So Sukuk structured under single Sharia concept should preferably be named according to the concept of the financing. Like if it is structured on the Ijara, it should reflect in the name that's Ijara Sukuk. But if it is structured on different concept, you may name it whatever you like. So regulator may decide on it. So Sukuk are, you also set condition here, the Sukuk should be convertible or not. Can it be convertible to shares, or it will be redeemed at the end of the period? What will the procedure of redemption again? So other condition what the regulator deems fit can put here in these Sukuk regulations. Another important area is the SPV, trust deed, the legal requirement and the ownership. So this is a very important area as I discussed. So generally the SPV is held by the trustee under trust deed. Therefore, any person issuing, offering for subscription or purchase or making an invitation to subscribe for or purchase any Sukuk will have to enter into a trust deed and appoint a trustee. So law should determine who will be eligible to be appointed or to act as a trustee. So rules for the trustee to be prescribed, who could be the eligible trustee, approval requirement for the trustee, maybe preconditions to be a trustee, like the trustee should not have any major interest in the Sukuk issuer or the originator or in the Sukuk or in the instruments, So trust deed relating to Sukuk must provide at least the key features of the Sukuk: profit rates, maturity dates, redemption schedule, denomination of the Sukuk, etc., etc. So detail of the depository company, paying agent of the Sukuk, whether the Sukuk are secured or unsecured, if secured, nature of the security. You see, so the ranking of the holder of the Sukuk amongst all other holders of the Sukuk and against all the other obligation of the issuer. So you need to basically give a standardized framework for the trustees as well as for the SPVs. Again, Sharia advisor, I've just discussed the requirement for the Sharia advisor. You need to prescribe in the rules who can act as a Sharia advisor, who could be. So his tenure, his operation, his powers, can he interfere in the administrative matters, can he interfere in the operational matters, or he is only relevant to the instrument or to the structure of the Sukuk. So this need to be defined in the regulations. Another important thing is the disclosure and reporting requirements. You cannot control or regulate anything if you don't have a proper disclosure and reporting requirements. So to protect the interest of the investor or the stakeholders, if you don't have any disclosure and reporting mechanism, so you cannot basically protect the interest of the investors. So disclosure, so you cannot control, regulate, and protect investors' interest, I must say. So the offering document, if the Sukuks are issued to general public, normally the issuers are required to prepare a prospectus. So prospectus, what information should a prospectus contain? So generally, a person issuing the offering for subscription or purchase, or making an invitation to subscribe for the purchase Sukuk is required to register a prospectus with the regulator. So the prospectus must be in compliance with the requirement of the law. the provision of the law should apply when the prospect is to be issued by the corporation, or what are the requirements of issuance of the prospectus, and if this permission and if not obtained from the regulator for issuance of the prospectus, what is the penalty for it? Like in Malaysia, it is 10 million Malaysian ringgit and imprisonment of 10 years, or it may extend to both. So for specific offer, like for privately placed school, the issuer will disseminate an information memorandum, you may require that to the potential investor. So it is considered a private document. It shall not be used as a document inviting public for subscription. So you can set certain standards, and again, requirement for that specific offer, to whom you can offer that, and in case of false information, misleading information, material omission, what is the penalty? So these are, these areas to be addressed here. So guidelines again on you may issue on due diligence.
Assalamualaikum, Brother Imran Binas.
Ji. So,
sorry to interrupt you. Actually, we have our closing ceremony.
okay.
And as request to you that we have to conclude this session immediately, so that all these people will go for the link for the closing ceremony.
Oh, sure.
Our
So
guests are waiting over there.
I think most of the part
Yes.
of the area of the regulations I have covered it, and again, so the reporting requirement, disclosure requirements, financial treatment, accounting treatment, Sharia audit requirements, regulatory order requirements, and the relaxation of rules. I mean, if you wish to give some relaxation of rules, so these areas needs to be covered in the regulation. Keeping in view the time lag, I wish to conclude here, and I'm thankful.
Minas, if you allow me,
Sure.
Can I
Mr. Bear, I can't hear you because I think there is some network issue. I can't hear you. So are you there, Zubair sir? Okay, I wish to conclude here, and thanks for your patience listening. So of course, it's very difficult job to hear after having a food, after having lunch. So I tried my level best to give you an overview of the regulatory framework for the schools. So I'm just waiting for Mr. Zubair Mughal to come again and join us and to conclude this session formally.
All right, sir. Thank you very much for your valuable insight and knowledge that you provided us. I thank you on behalf of Sir Zubair Mughal and Alhuda CIBE, as well as Bangladesh Securities and Exchange Commission. So to the participants, I would request to follow the link provided in their WhatsApp groups, as well as the chat box, so that we may start our grand closing ceremony. Thank you very much, and Allah Hafiz.